Welcome to this Master Series special event, SB 1162, What Studios Need to Know About California's New Pay Data Reporting Law. My name is Pantea Lili Ahmadi, and I'm the Director of Corporate and Employment Law here at Entertainment Partners. Joining me today are Alan Wu, Director of Employment and Labor Relations here at EP, as well as Joe Scudiero, our SVP and Chief Labor Counsel. Today, we'll be discussing California's new Pay Data Reporting Law, SB 1162, and how it applies to the entertainment industry. This is general information only, and it's not intended to be legal advice. So anyone listening and tuning in today should be sure to consult with their own labor counsel about their own specific situation and how this law may or may not apply to your particular company. Alan and Joe, it's so nice to see you, and thank you for joining me today. Okay, so Joe, there's a lot of buzz about this updated pay data reporting law in California, SB 1162. So why don't you tell us a little more about this new law?
Sure. And hello, Pantea. Hello, Alan. It's good to reconnect with you, Pantea, on California pay data reporting. It's been, a couple years since we presented our C973 webinar for the industry. That was a lot of fun, and we have a lot to cover today. So let me start, Pantea, by noting some background to reorient all of our listeners on the original law, SB 973. It was first implemented in 2020, late 2020, and it required initial government filings to California in 2021. A couple notes to keep in mind regarding that law that are going to be important here when we begin to discuss some very key enhancements. Number one, SB 973 applied only to private employers who met the coverage requirements under the law, who filed or were required to file EEO1 reports. For most of our listeners, they're aware that an EEO1 report is a report filed annually by large employers, 100 or more nationwide, with the EEOC that provide a breakdown of an employer's workforce demographics, race, and gender. Secondly, SB 973 applied only to direct hire employees insofar as production workers were concerned. And by that, I'm referring to production payroll type employees. It was construed really not to cover temporary workers from contingent labor services. So as we'll see on those notes, SB 1162 has made some significant changes. It was passed in late 2022. It will require filings for calendar year 2022 by May 10th of 2023. The California Civil Rights Department, which was formerly known as the Department of Fair Employment and Housing, is the agency in charge of the law. And the California Civil Rights Department has issued some additional guidance in the form of FAQs, a user guide, and a complex template to use to report all of this information to the state.
Thank you, Joe. So I think you touched on this in your answer right now, but how is SB 1162 different from California's previous pay data reporting law, SB 973? Basically, what are the key differences between these two laws?
Keeping in mind my comments about the background about SB 973, how it had limited application to employers who also had to file EEO1 reports and applied only to so-called direct hire employees. There are probably about four major changes that we're going to cover in today's webinar. Number one is SB 1162 has expanded the scope of employers who will need to file under SB 1162. So again, whereas SB 973 applied only to employers that filed those EEO1 reports, SB 1162 does not contain a federal EEO1 filing requirement. So it's very clear that all private employers who meet the coverage requirements under SB 1162 must file pay data reports under the law, regardless of whether they are required to file an EEO1 report for certain groups of employees. Second, the scope of employees that employers need to report for has been greatly increased. So employers now will have to file two reports. Right? One is a payroll employee report, which existed under a different name under the original iteration of the law. But now there's another report that employers will need to file called a labor contractor report. And this is going to cover those temporary workers who are supplied by third-party temporary service agencies, staffing companies, and so forth. And we'll talk more about that concept later. Third, there's a new data component regarding the inclusion of the mean and the median hourly rates for employees, which we'll cover. And then finally, fourth, SB 973 really had very little in the form of an effective enforcement mechanism. There were no monetary penalties at all under SB 973. SB 1162 now contains hefty financial penalties. The penalty is $100 per employee for an initial violation and $200 per employee for subsequent violations. So you could see with a significant volume of workers, those penalties can add up quickly.
Sure. Thank you. So you referenced a fact that under SB 973, employers were only required to file one report, right? And now you're mentioning that there is a potential second report for labor contractors. So, what is a labor contractor? Alan, if you could, help us out with this, that would be wonderful.
Sure. Hi, everyone. A labor contractor under SB 1162 is defined basically as an individual or an entity that supplies a client employer with workers to perform labor within the client employer's usual course of business. And so you think about those staffing companies or temporary service providers that Joe mentioned earlier. In the entertainment industry, you think about on your productions, where do you get your background actors from different casting companies, Central Casting, for example? That's the labor contractor concept. And if you have one or more labor contractors during the calendar year, this year in 2023, when you file the report for the 2022 reporting year, employers may have to file both, a report for its direct hire employees, as well as a report for workers that are procured from labor contractors.
So, Joe, circling back to you real quick, why does the California Civil Rights Department even want this information to begin with?
Good question, Pantea. If you look at the guidance that was issued in the form of the FAQs, the stated reason that the Civil Rights Division gives is to create self-awareness for employers, to look at the breakdown along racial, ethnic, and gender lines in their workforce and to make self-corrections moving forward for diversity, equity, and inclusion purposes. But there's another reason here, and that is the Civil Rights Department is empowered to enforce this law. And this information is designed to assist the Civil Rights Department to identify instances on its own of racial, ethnic, and gender employment practices and pay practices that may not comport with a law or may suggest inequities among those practices, and use this information to aid in the enforcement of anti-discrimination laws, which they are empowered to enforce, which will also include prosecutions of companies that don't comply with the pay data reporting law or show patterns of discrimination. So there are some serious consequences to these reports. One takeaway here is even before filing the report with the CRD, the Civil Rights Division, employers should carefully scrutinize these reports internally to ensure that they paint an appropriate picture for the state of California to review.
Sure. Thank you, Joe. And Joe, real quick, before we get into the details of this law, how will this impact the entertainment industry?
Yeah, that's the ultimate question. Right? It's always been clear, Pantea, under SB 973, and it's the same under SB 1162, that between the motion picture payroll service companies and the production companies or studios, it's the production companies and studios that carry the responsibility to file these reports for talent and crew because they operate as the common law employer. First true takeaway from the new law that's critical for the industry to understand is that production companies and studios can no longer rely on any federal EEO-1 filing exception for talent and crew to be excluded from reporting under SB 1162. So that's really the major takeaway. So that leads to a few issues, high-level issues for production companies and studios. So one is they should consult with their legal advisors regarding whether or not they're covered by the law and whether or not they need to file payroll employee report for the direct hire talent and crew, or the labor contractor report for labor contractor hires, or both, right? As we discussed. Along those notes, it's also important to confirm to what extent the production company has received contingent labor, temporary workers from any source, including background actors from casting agencies and central casting, or other types of contingent labor that may need to be captured in these reports.
Thank you, Joe. Alan, switching to you for a second, I remember that embedded in SB 973 was this concept of a snapshot period, and that snapshot period concept is also included in the text of the updated law, SB 1162. So can you tell us just very quickly what a snapshot period even is?
Sure. A snapshot period is basically one full pay period for the employer, and that pay period must fall within the window of October 1 to December 31 of each year. So this year in 2023, when we're looking back at 2022 for the reporting year, employers have to pick a full pay period that lands between October 1 and December 31. And depending on the calendar year, sometimes your payroll period can start a little earlier than October 1 or end a little later than December 31. You can't pick those pay periods because you have to pick one full pay period that falls within that window, and that pay period becomes your snapshot period. And it's important to note these two separate reports, where a report for your direct hire employees and a separate report for employees that are procured from labor contractors. The CRD calls those labor contractor employees, that employers can actually pick different snapshot periods for both of those populations.
So employers who have to report need to report on a particular snapshot period. So let's talk about just basic coverage, right? So which employers are even obligated to file this pay data report in California? Right.
So it's private employers that meet a certain threshold of employees. So that is, if you're a private employer that had 100 or more employees during the reporting year, so looking back at the 2022 reporting year, if during that calendar year, the employer had 100 or more employees nationwide, and at least one of those employees were either working physically in California, or maybe they were working remotely outside of the state, but they are otherwise assigned to and reports into an establishment that's inside California, you would count that worker as well. So at least one California worker out of that 100 or more, then you've triggered this obligation to report. And that threshold is the same number, but a different threshold for both reports. So if you have 100 or more direct hires, and at least one of those is a California worker, or you had 100 or more labor contractor employees, and at least one of those is from California, then you would have to file those reports. So you might end up with filing both of those reports or just one of those reports.
Sure.
So, hey, Pantea, can I just jump in real fast?
Oh, sure. Welcome, Joe.
Question. So, Alan, you talked about the snapshot period, and then you also talked about employer coverage. Coverage requires 100 employees nationwide, one employee in California or reporting to California. What is the difference between the coverage and the snapshot period? Could you give an example so our listeners understand?
Sure. So for purposes of triggering the obligation to report itself, that's where the 100 or more employee threshold comes in. So if you look back at your 2022 calendar year and you had 100 or more employees in either of those two populations, and one of those employees is in California as a direct hire, or one of those employees on the labor contractor side, one of those employees is a California worker, then you trigger that obligation to report. Now, the snapshot period, that one pay period I mentioned earlier that lands between October 1 and December 31, those are the workers that you actually have to include in your report. So let's say that, I'm a private employer and I've determined that I did have 100 or more direct hires during the calendar year. Now I pick my snapshot period. Let's just say, for example, I pick the third payroll period, actually in October. That payroll period, I only had 50 workers that I was employing. Well, you still trigger the obligation, right? Because you've had 100 or more employees in that calendar year. But in the report itself, you're only going to report on the employees that are in your snapshot period. So in my snapshot period, I had only 50 employees, and I would include those 50 employees in my report.
No, thank you, Alan.
So, Alan, which employees generally need to be included in the report?
Sure. It is the employees that are within your snapshot period, right, that I mentioned earlier. So let's say that I picked the third payroll period in October and I only had 50 employees in that snapshot period. Those are the 50 employees that I'm going to include in that report. But keep in mind, though, because this is a state law, the state is only interested in your California employees. So you might have different establishments outside of California, but the state only wants to know the data on your California workers. So people who are either working inside the state or maybe they're working remotely outside the state, but they're otherwise assigned to or reporting into an establishment that's inside California.
Can I ask a quick follow-up? Because with the advent of remote work, this is a very important concept, right? In 2020, remote work was kind of just getting started. Now it's very clear, right? As you pointed out, Alan, that any employees who are working outside of California, but reporting into or assigned to a California location are covered by this law. So how important is it for employers to take steps to ensure that they're capturing these remote workers outside of California, but who are working for a California office? Why is that important moving forward for these pay data reports?
Right. So if we think about the new penalties that are in play this year that you mentioned earlier, the $100 per employee penalty for initial violation or $200 per employee for subsequent violations, that's going to add up. And so now, if you don't include those remote workers, you are subject to potential penalties from the state.
Thank you, Alan.
Now, Joe, let me ask you a question. Let's say I'm an employer. What if my company has multiple divisions or related entities that separately don't meet this 100 or more employee threshold that you guys were talking about, but combined would meet the threshold? What happens then in terms of a reporting obligation?
Excellent question. The answer is it's a complicated analysis, but here's some general guidelines. For some employers, this may be a relatively straightforward analysis. There may just be a single employer. And I'm going to give a little bit of context, Pantea, before I get to the precise answer here, but just want people to understand the dynamics involved here. So remember, it's a common law employer responsibility. Some organizations may have a single common law employer, in which case reporting, assuming there's coverage, will be relatively straightforward, at least in terms of identifying who the reporting employer is. In other organizations and in most studio and production companies, there will be multiple divisions, departments, production entities. And to the extent these divisions and entities constitute separate employers on their own, on a common law basis, they too would be required to file separate reports, assuming there's coverage analyzing each individual employer. Now, your question, which was great, is asking, well, what if those separate divisions and entities individually do not satisfy the 100 employee coverage requirement in order to be covered by the law? So the answer is those separate divisions and entities would not need to file California pay data reports unless, and this is covered in the guidance, and it was a concept embedded in the original law, SB 973, unless all of these companies taken together constitute what's called an integrated enterprise, which is really an analysis based on common ownership and control, in which case say 2 divisions comprised of 60 employees each nationwide with California employees would be combined and would include 120 employees and therefore exceed the coverage threshold. So the bottom line is it's a very complicated factual and legal analysis. We would highly recommend, as you pointed out at the beginning, that employers consult with legal counsel regarding how they would have to treat, their specific situations.
Definitely. Thank you, Joe. Now, Alan, let me ask you a question, which is different than, separate and related entities potentially, but also there's this notion of an establishment that was referenced in both SB 973 and that reappears again in the text of SB 1162. So what is an establishment?
So an establishment is defined as an economic unit producing goods or services. Simple as that. So examples could be a store, a factory, a warehouse. For the entertainment industry, it could be a particular studio facility. It could be, each individual production can also be their own establishment.
Quick follow-up question for Alan on establishment. So Alan, I could see many clients looking at the question, okay, I'm a single employer, let's say to make this example straightforward, I have one employer, but I have multiple establishments. So in that case, does the employer need to file a separate report for each establishment, or is one report sufficient that covers all establishment? How has the state of California set this up for reporting?
If you look at the template and the FAQs for the reporting, the template is designed so that each employer files for all of its establishments. Let's say in your example, right, you have a single employer, but multiple establishments. What you would have to do in the report is put all your establishments under the same report, but separately identify each establishment, right? Establishment A, establishment B, whatever it is that you use to identify your establishments. And so it's by employer, not by establishments.
Okay, thank you, Alan. Appreciate that.
Thank you, Alan. So now let me ask you a question. So now we understand if you have multiple establishments, how you report on these particular establishments, right? So now what data should be included in these reports, which could potentially be massive, I understand.
Indeed. So after our listeners hear the answer to this question, they'll realize that it will take a long time to gather this data. This is probably it is the most laborious part of the entire process. And so what we're discussing here is just requirements, the law, but the actual gathering of this data and breaking it down, that is going to be the most intensive part of this reporting obligation. So what you need to do is, once you've identified your snapshot period, again, for both of those populations, your direct hires and for your labor contractor employees, you break them down by the establishment. And then you have to break them down even further by many other factors. The first thing is job category. There are 10 different job categories that you have to slot your employees into. There's a guidance document on how you would determine how to slot your employees into these 10 categories. A couple of examples of these 10 categories are technicians, professional, service workers, craft workers, 10 of those categories. And then you have to divide up your employees by their race and ethnicity. And there are 7 of those that are acceptable to the government, which also matches what's in the current federal EEO1 reporting, as well as the 10 job categories that I was referencing earlier, also matches the 10 job categories that are currently in the federal EEO1 reporting. And then you have to break down the gender by male, female, or non-binary. Those are the 3 options that the state accepts. Then and then you have to gather each of those workers' W-2 data from that reporting year, right? So here in 2023, you will need the 2022 W-2 data for each of those workers and slot them into 12 pay ranges, also referred to as pay bands. Just from that alone, you'll have many different permutations, right? So if you have 12 Asian males who are in the category of craft worker and their pay band is just, it's going to make up a number, 53,000 to 58,000 at one establishment. Let's call it production X. right? That's one permutation. And then let's say you have 4 white females in the job category of professional, and let's say they're in a higher pay band who also worked at the same establishment, and then that's a different permutation. So from that, you can see how many different permutations there are among the job categories, gender, race and ethnicity, salary range. We did a little math, and I think it was 2,500 plus possible data point permutations. And then, so not only that, after you aggregate your people into all these slots, into each group, each permutation, you got to figure out for each of these permutations what their mean and their median hourly rate is. So for those of you who have middle schoolers in your household, go ahead and ask your middle schooler, what is a mean? What is a median? That is something that the government also wants. And so the FAQs, right, also cover this. And you might be wondering, well, why would I have an exempt worker or an on-call person who doesn't have an hourly rate? Well, the FAQs also help you on that question of how the government wants you or expects you to figure an hourly rate for those people in order for you to determine what the mean and the median hourly rate is. And then lastly, for all those workers now, from your snapshot period, once you determine all those permutations I mentioned earlier, the government then wants you to calculate in the aggregate for each one of those permutations, what was their total hours worked during that reporting year. Let's say you pick the 3rd payroll period in October in that snapshot period. For those 50 people, you look at their entire calendar year of 2022 and calculate how many hours were worked by those 50 people, but you have to break them down by those permutations I mentioned earlier and then aggregate that number into each of those permutations. The government FAQ says don't annualize the hours worked for people who don't work a full year. So let's say somebody worked up through October and they stopped working for you in November and December. Don't annualize their hours. Just report on what their actual hours were during that full calendar year.
Alan, just 1 second, Pantea, if I can. So yes, that is incredibly complicated, and I'm not trying to complicate it further, but I think it's important to clarify the concept of aggregating hours and pay on an annual basis, and then including those numbers in these reports, for the employees who appear in the snapshot periods. And you explained all of that very well. I guess my question is, when you are annualizing hours and pay for someone who worked in your organization, let's say that employee worked for, say, 2 different common law employers within your organization, would there be a need to apportion the hours and pay across each common law employer, or would it be just annualized and roll up to a higher level?
So in your premise, you are saying that there is more than one common law employer.
Correct.
So going back to what we were referencing earlier, each employer that separately meets that 100 or more employee threshold, they have to file their own report. And if your worker in that snapshot period happened to work for both employers, both common law employers during that snapshot period, then yes, you would have to apportion those hours for that worker. And so you would have to count up all the hours that the person worked in that year under common law employer 1, and then put those hours under the common law employer 1's report to the state, and then do the same thing for common law employer 2's report, add up all that worker's hours for the year for under common law employer 2, and include that data point in common law employer number 2's report to the state.
That's what I thought. Thank you, Alan.
Just as complicated as we already thought. So let me ask you a question now, Alan. How does the employer go about submitting this laborious report to the Civil Rights Department?
It's all through the web, right? Modern age, it's all through the web. So the government has put out templates that employers have to use. It's either an Excel file or a CSV file. There's also a third option, which is to answer online form questions, which are also on the portal. Most larger employers are probably not going to find it useful to use the online forms. They're probably going to use the template instead. So each employer has to go to the Civil Rights Department website, register and create an account, and then upload their reports into their account to the state via that web portal.
Okay, thank you. Now, Joe, let me ask you a question. Let's say for whatever reason, whether it be that the employer just doesn't know or understand that they have a reporting obligation under this law, or the employer can't get its pay data report together in time because it is so extensive, as Alan made very clear. But for whatever reason, the employer just doesn't file the California pay data report by this year's May 10th deadline. What happens then?
Thank you, Pantea. And this is very important for employers to understand. There are serious consequences now attached to a failure to comply. So first, whereas there were no financial penalties under the predecessor law, SB 973, SB 1162 has now added these very substantial financial penalties that I had mentioned at the outset, $100 per employee for an initial violation, and $200 per employee for subsequent violations. So if you have a workforce, say of 1,000 employees for a snapshot period, which would not be unusual or be relatively common for many employers in the entertainment industry, the financial penalty alone could range up to $100,000 for the initial violation. Second, there's always been an enforcement mechanism for the California Civil Rights Department to go to court and compel filing of these documents by employers. One thing to note is that it would be a public proceeding. So there could be media attention attached to that type of a proceeding, which leads me to the third point, which employers should appreciate, and that is the reputational harm that companies could suffer by not complying. We all know that there's increasing attention to diversity, equity, inclusion among several fronts. Workers, the public, the media, corporate boardrooms, shareholders, and all of this motivating employers to be more transparent with employment practices, demographic statistics, and pay practices that advance diversity, equity, and inclusion in the workplace. And then when you couple that goal with the mandate of the California Civil Rights Department to reduce discrimination and promote equal pay practices, the reputational harm component could be very significant. Finally, even outside of government action, there's the potential for non-compliance to arise in a private lawsuit filed by a former employee for discrimination. And we would not be surprised if clever plaintiff attorneys use the fact of non-compliance as evidence to show that the company engaged in a pattern of discrimination or unequal pay practices.
To argue that, but yes. So let me ask you a question. You kind of reference this concept of bad press, right? So employer not submitting a timely pay data report or whatnot could be just not good for an employer, right? So are these reports made public by the California Civil Rights Department since the employer is filing with a third-party governmental entity?
No, thank you. That's important to understand too, because the original press, according to the bill that was introduced, would have made these reports public. So there was that attempt early on in the legislative process to compel the department, or the Civil Rights Department now, to make these reports publicly available on specific employer basis. But that was dropped due to pressure from the employer community. So to answer the question, Pantea, for now, the reports are protected against disclosure by the government. The Civil Rights Division has always had the ability, and I believe they have disclosed statistics in the aggregate on an industry-wide basis without attribution, of course, to any particular employers on their website. That will continue. Don't be surprised if various constituencies in Sacramento continue to push the Civil Rights Division by legislation to publish these reports in the future, again, to promote diversity, equity, and inclusion efforts and to encourage employers to take self-corrective action to improve workplace demographics and pay practices. And then finally, Pantea, just going back to the private litigation angle here for a moment, when you think about it, even though these reports are not going to be made public by the California Civil Rights Division, there's still the possibility that these reports may surface in private litigation
Sure.
where a plaintiff's attorney is making a discovery request, right, for these reports and potentially could use, one of these reports to show pay differences across race, ethnic, and gender lines by the employer.
Thank you, Joe. So to sum things up, Joe, what are the major takeaways for production companies and studios?
But this is incredibly complicated. This law was complicated 2 years ago when it was in. We've struggled with it, explaining it and helping clients manage through it. And for the most part, we've really only touched on the requirements today in a very high level way. There's unfortunately a lot more detail here, in the reporting process and in the data requirements that we have not touched. The first takeaway is it's going to be very complicated to sort through it and to manage it. So what do you do if you're a production company, studio client, a VP? Number one is please confirm with your legal advisors if your company is covered and if your company must file under the law. Remember, the EEO1 filing obligation that many in the industry took advantage of not to report in California has now been eliminated. All right. So all companies that meet the coverage requirement must file these reports regardless of whether they file those EEO1 reports. Second, confirm whether or not your organization must file just the one report, the payroll employee report, or both the payroll employee report and the labor contractor report for all the temporary labor workers, including background actors that your production organization is receiving from central casting or other casting companies. If you are covered, please begin the process now to identify the various sources of where all of this demographic and pay data is going to come from that you'll need to report. We recognize here at EP that to a certain extent, this is going to be a collaborative effort. We are fully prepared to assist all of our clients with respect to general information and data to facilitate reporting under this law. And as I mentioned, for those of you who have not reported before and have to begin to sort through this, it's going to be very difficult. Pantea, you mentioned earlier, the reporting deadline is May 10th of 2023.
That's correct.
I would start confirming whether or not your company is covered and working through all of the data and reporting elements now. And so a final note about how EP can help our clients. Many of you know that we developed the first tool that I'm aware of that was specifically dedicated to the industry to facilitate reporting under SB 973. And it was instrumental in helping our clients to be relieved from the burden of manually pulling and sorting through and organizing all of the data and reporting it to California. So just as we help clients with the SB 973 solution, EP has developed a product that is specifically tailored to meet, the new demands of SB 1162 for the entertainment industry. This product is going to enable studios and production companies to compile, organize, and translate all of the necessary race, ethnic, and pay data points using the required California Civil Rights template to report all of this information to the state of California. So thank you very much, everyone, for tuning in. We greatly appreciate it.
Thank you so much, Joe and Alan, for walking us through SB 1162 and for giving us a glimpse into how it will apply to the entertainment industry. For our viewing audience, if you have any questions about SB 1162 and its reporting requirements, we encourage you to visit the SB 1162 landing page of our website or to reach out to your EP account manager for more information about how we can help. Again, this is all intended to be general information only. It is not intended to be legal advice. And to all of our viewers, please be sure to consult with your legal advisors about your current situation of your company. And on that note, thank you very much for joining us.